Okay, good afternoon, everyone. Welcome to the Program in Criminal Justice Policy and Management's speaker series on the myths of public safety, and in particular, the myths of public safety in the pretrial context. This is an event series that will be happening almost every other Wednesday this fall. And in fact, we've already had a few, and there is now video available for one such event. The first event we held this fall was with the Pretrial Justice Institute about their What If campaign. Folks can find video on our past events page here or on the individual event page, which is also linked here. We'll be recording this event. In fact, recording is already in progress and making this event available for public dissemination in the same way after the fact. It takes us usually a little bit of time to get things up on our website just because we have to do some closed captioning work and make sure things are accurate and accessible. If people have questions for our wonderful guests during the course of this event, which I haven't said already, but you had the screen up, so folks should know you're in the right place if you're here for the event on the Pretrial Fairness Act and fighting disinformation, and really the essential question of does reform affect community safety? I think our panelists are going to give us a lot of research and data to back up the policy change that we're looking forward to in Illinois. But in any event, if you all would like to ask questions during the course of this event, please feel encouraged. There will be specific dedicated time at the end, but people can raise hands or drop questions in the chat as we're going, and we'll try to weave them into the conversation. And in fact, people are welcome to ask their own questions. So if you want to put a placeholder in the chat, but then we can open up and you can expound on the question. We have a couple other events upcoming in the series, as we mentioned, and you can find all of those on our website. The next one will be November 16th with Aditi Goel at the Sixth Amendment Center about early appointment to counsel and the kind of failures in systems around the country to get people access to constitutionally required counsel early enough in their cases in some jurisdictions. And I think that brings us up to speed with the housekeeping we've got to do this afternoon. So to begin, I'll introduce Sharone Mitchell and Will Tanzman. Sharone is the Chief Defender of the Cook County Public Defender's Office, and Will is the Executive Director of the People's Lobby, an organizing and community-based organization that's based in Chicago as well. And we're so delighted to have you both here. You can read their full bios on the event page, but in the interest of time and moving into our conversation, I think we'll skip that for now, and folks can find those online. And welcome to you both. Thank you so much for being here.
Thanks for having us.
So to begin, I figured it would be helpful to kind of set the stage for, before we can talk about the backlash to the reform, I think it would be helpful to talk about how it came to be in the first place and what the idea was behind pushing this policy forward. So how did you two start working together on these issues and through the Coalition to End Money Bond and the Illinois Network for Pretrial Justice?
So my organization, the People's Lobby, came to it because we were organizing with churches, especially Black churches that had members and leaders who were, who either themselves were directly impacted by incarceration or had friends and family who were impacted. And one of the stories that kept coming up was people being locked up because they were poor and couldn't afford bail. And then this meant, as it turns out, as we discovered, that people, although people are supposed to be innocent until proven guilty, they were being locked up for months or even years, where no evidence was presented, but there's a bond hearing that lasts 30 seconds or a minute, and the prosecutors say this person's accused of X, Y, and Z, and the defense attorney says one sentence about the person having a job or family, and then the judge says, okay, bail set at $50,000, and that's it. The accused person can't come up with bail, and they're sitting in jail. So we're hearing these stories. These stories were coming out in these, coffee hour conversations at church. And so we sort of started a collective process at our organization where members and leaders were looking into this issue, finding out more about it, how it was playing out, watching bond court, finding other organizations working on it. So that's how I got introduced to Sharone, and we got a chance to work together through this coalition. And it's been a really great 6 years now of working together on this.
Yeah, thank you so much for having me. This is probably the closest I'll get to Harvard ever in my life. So happy to be here. But listen, I started my work as a Cook County public defender And I'm born and raised on the south side of Chicago. And in my 7 or 8 years in the public defender's office, kind of the first time around, I saw the real impact, pretrial detention has on the legal system. This idea that a person's presumption for innocence is up for sale, and that somebody in jail has significantly less rights than those outside, the denial of that ability to, quote unquote, fight your case, is something that I saw as a real issue. It's really not only as a defender, but as somebody who just grew up in the city and is affected by the legal system. So I had the opportunity to go work in policy after my time as a public defender, and my organization was the kind of this policy organization, like literally in an ivory tower. Like it was like a ivory tower. It was called Illinois Justice Project, this downtown organization. And I was, looking for ways to take my experience as a defender and apply that to policy. I learned pretty quickly that, as a defender, that the things that we think that are like defects are really benefits. They're existing for a reason. So I wanted to take my experience and got involved with the coalition to end money bond after a talk, an event that I did, and connected with a bunch of other folks like Will, and got a chance to join the coalition and got a chance to be a part of the work. So started about 6 or 7 years ago, and we've been rocking ever since.
Phenomenal. And so the coalition formed years before this law actually came to fruition. So how did that kind of existing organizing infrastructure propel you towards this specific legislative campaign? How did the law come about, and kind of who were the stakeholders behind it?
Yeah, so we started with more of a Cook County specific fight. When the Coalition to End Money Bond started in roughly 2016, we were coming off of the heels of a big electoral fight to elect Kim Foxx as Cook County State's Attorney against the much more tough on crime Anita Alvarez, and State's Attorney Foxx won big on a platform that very much included bail reform, and a bunch of movement organizations, including the People's Lobby, had done a bunch of work knocking doors for her on that. And so we were kind of looking for ways to turn that electoral energy into policy change. So we started, I think we tried a bunch of different things until we got to the Pretrial Fairness Act. We started with a much more earlier iteration of state legislation that kind of didn't really go anywhere. And then we all put a bunch of pressure on the Chief Judge, Tim Evans, who then created a bail policy that required judges to issue bail amounts only within the limits of what defendants said they could afford to pay, which was unevenly enforced, but did lead to some pretty significant reductions in pretrial incarceration. And then we we engaged in a fight at the Illinois Supreme Court to try to get the Illinois Supreme Court to issue a rule, and then kind of came back around to state legislation over the course of that 4 or 5 year period.
Yeah, there's such a lesson even in that story of thinking holistically about, from an advocacy perspective, right? Fighting on every possible terrain to try to move the needle in shifting policy. I think it would be helpful, Sharone, if you could tell us a little bit about, once that policy finally was drafted in this legislative format, what are some of the key pieces that are included in the policy?
Yeah, thank you so much for that question. So the big piece of legislation that was signed is an omnibus piece of legislation called the Safety Act. It was signed into law in January of 2021, and it included 3 really big parts: parts on pretrial, parts on safety, parts on sentencing, and parts on policing. But it was kind of what's called an omnibus. So there are lots of different kind of pieces within that. Within the pretrial section was what we call the Pretrial Fairness Act, which is this law or suite of laws that advocates have been fighting for several years, including the Coalition and Money Bond. And what the law is billed as is accurate. It is the end of cash bond. It's removing money as the determining factor in whether somebody should go to jail or should not be in jail pre-trial, before a decision's been made on innocence or guilt. But I think it's better described as kind of a wholesale, almost reimagination of the process in determining whether somebody is going to be detained or not detained. Oftentimes, in the status quo, well, not oftentimes, when somebody goes before a judge, a judge has a decision either to hold that person, release that person under both of those scenarios, the case still goes on, or offer that person a money bond. And that money bond essentially is, hey, you're eligible to leave, right? You're eligible to free to fight your case from the outside, but you essentially got to pay the government a ransom. And we know that the vast majority of people in the criminal legal system are poor. That's the reason why my office, the public defender's office, the office I'm a part of, our attorneys represent the vast majority of people in the criminal legal system because the vast majority of people in the criminal legal system are poor. So using money never made sense. And there are all types of outcomes, whether we're talking about bad decision-making or whether we're talking about all that money being removed from Black and brown communities. So the Pretrial Fairness Act basically moves us from 3 outcomes to 2 outcomes. We're making either detention or release, but it doesn't stop there, because if we just stop there, we would not be happy with a reality where we have no cash bond, but everybody's detained. So it creates a kind of process for making the determination of whether somebody should be detained or not detained, and creates a whole kind of system of changes, a whole kind of universe of changes to ensure that people aren't incarcerated just because they're poor, or just because the system's lazy, or just because the process is kind of just old and just kind of leaning toward people being detained for very, very silly reasons. So that is kind of the bill, the law in a nutshell. We can get more into detail, but that's kind of the basics of it.
Yeah, that 10,000-foot view is really helpful for grounding, I think, the next phase of the conversation. And I think we will get into more detail as we start going through some of the kinds of myths that have been leveled against the law, and sort of what the specific pushback is about what the law really does or will do. I think part of the concern so far has been the law has yet to even take effect, right? You haven't seen it actually be realized in courtrooms in the way that hopefully come January 1 it will be. And I think there's still so much misinformation about what's happening right now on the ground and how courtrooms are affected by this at the present moment. But I think one other piece before we move on from just that landscape laying that I think is so important about this law is that connection between cash bail and wealth-based detention, but also other forms of pretrial detention, right, and other triggers for pretrial detention. I think so much of the efforts in a lot of jurisdictions have been focused very narrowly in kind of a silo on cash bail, which can lead to upticks in other forms of pretrial detention if there isn't kind of careful attention to make sure that you have that holistic approach. But the research on pretrial detention says, regardless of the source of the hold, the harms of jail are consistent across for people who experience those harms, right? And I just want to drop in the chat a link from our faculty chair, Sandra Susan Smith, who has released this publication about pretrial detention and pretrial release and public safety, right? And the kind of overwhelming evidence suggests that pretrial detention creates tremendous harms and does not produce safety in the way that I think is the dominant narrative in many cases, at least. So before we move on from the background setting, I think one other piece that feels really significant about this campaign is the centrality of racial justice, right? In this campaign, the focus on this coming from the ground up from Black and brown communities, Black churches in particular, right? In your work, Will, where directly impacted people were saying this is something we're seeing in our communities and we want to see that change. So how was that part of a central piece of the campaign, and why is it important in your work to keep that kind of front and center in reform efforts?
Yeah. So in Cook County, 25% of the population is Black and 75% of the people incarcerated in Cook County Jail are Black. Those numbers are even worse in other counties. like it is true that money bail is an economic justice issue because people are being locked up for being poor, but because of the incredibly high level of racism at every level of the criminal legal system, from policing to risk assessment tools to the root causes of crime and violence to prosecutors to judges to, we just go on and on and on. So you just can't have a real conversation about money bail without racial justice being at the center of that conversation. So we did our best to make that central piece of the campaign. You know, sometimes we succeeded more than other times. It is easy for people to kind of default to talking about wealth-based detention and the sort of economic justice element of it because it's like literally money bail. But if that's the conversation, you know, we're missing such a huge part of the picture.
Absolutely. Anything to add on that, Sharone?
No, I think that I would only add that, and I don't know if it fits into the question, but I'm just going to say it anyway.
No, that's fine.
I think it's really important to note that there's so much about the criminal legal system that exists only because folks who are in the system are just used to it, right? And it's a thing that the person that trained them to do. And I think this movement was an example of folks on the outside of the system. A lot of times it's accused people, a lot of times it's Black and brown families just deciding that this practice was unacceptable and they wanted to fight against it. If left to the folks in the system, we would still have cash bail, or cash bail wouldn't end in January because we're just comfortable with it. It's something that's always existed. It really took folks on the outside. It really took an acknowledgement that money bond is a huge tax on Black and brown women, that it just wasn't acceptable. So I just want to just point out the fact that it was folks on the outside deciding a policy that we just are super used to on the inside. Like, we needed to be told this was not acceptable, and this is how it happened. And I think a lot of that came from Black and brown communities at the center of that kind of resistance.
Absolutely. 100% correct. So switching gears a little bit to now talk about some of the kind of critical reception of the bill and the fact that it's sort of pushed people who developed and backed and built the campaign to enable it on the defensive. Sharone, can you tell us a little bit about how this started bubbling up? When did the critics of the law start to kind of inform and control the public narrative about this?
Yeah, well, like I said before, even before its signature, you know, the status quo, like the powers that be, were always kind of resistant to this idea that you could end cash bond, right? And certainly we've seen it happen in another state, New Jersey, essentially happened, which was kind of a paradigm for what we've done. But you saw that resistance. You saw the Taylor and Floyd uprisings, you know, create a moment in time in which this thing could pass. With that said, there was so much momentum, there was so much organization, there was so much work done with the Pretrial Fairness Act. I don't want people to think that, oh, this only happened because of that moment, right? This was something that organizers and advocates had pushed the governor of the state to commit to doing, right, before that, you know, that moment in time. But that moment in time happens. It's kind of signed on January of 21. And you see kind of some murmurs, but not a lot, right? There's not a lot going on. You know, during that time, you know, the serious people in the room are working on implementation. They decided that, you know, this is what's going to happen. It is a law of the land, so we're going to work to make this happen because there was a 2-year gap, right? When the bill was signed in 2021, you know, it wasn't going into effect until 2023. That was intentional to kind of think about how we were going to do this. And as we started getting closer and closer and closer to implementation time, and closer and closer and closer to an election, you really start to see a ramping up of attacks on this suite of reforms. And you know, it is impossible, I think, to detangle political fights for power and the well-funded campaign we are currently seeing against the Pretrial Fairness Act. You really see it as a proxy, right? As a point of attack when it comes to, quite frankly, a gubernatorial race and certain legislative seats, legislative races. That is the majority of the attack, and it's quite frankly based on lots and lots of lies. You do also have a subsection of people who are just very comfortable with the status quo, right? Who are either prosecutors, downstate prosecutors. Actually, the prosecutors of Cook County and Lake County, which are the two largest counties in the state, account for more than half of the population, supported this, right? You've seen other prosecutors. Illinois is a very weird state. There are like 102 counties, right? Like you have half the population is in like 6 counties, but you have all of these small public all these small counties with their elected officials, then kind of glomming on to the political attack. And there's a little bit of overlap there, but basically resisting this wholesale change, right? And arguing that it had to change. So as you get closer and closer and closer to the election, you see more and more and more and more money, pumped into this really, really, really terrible campaign. And I think Will could probably take it from there.
Yeah, absolutely. I definitely want to hear from Will about the moneyed interest. I just want to put a pin for ourselves in the example of New Jersey so that we can come back to talk about that and kind of the fact that there are already states that have done efforts at wholesale reforms and kind of what the lessons learned are in terms of, the forecasting of this public safety disaster, right? But putting a pin in that, Will, if you want to take it from here and kind of pick up the baton from Sharone about the specific moneyed interest behind this campaign, right? Who are the players who are driving this negative campaign in an effort to maintain money bail?
Yeah, so there's a few different kind of buckets of actors here. Earlier this year, at a much smaller scale, the Fraternal Order of Police started heavily supporting candidates who were running against people who'd voted for the Safety Act. So we had to knock a lot of doors to make sure those folks got reelected. But the FOP was very dead set against it and willing to put their money where their mouth was. They fortunately lost all of their primary election battles, but then the bigger money has come from a couple of billionaires. Ken Griffin started putting huge amounts of money into supporting his kind of pet gubernatorial candidate, Richard Irvin, and used a very sort of fear-mongering crime and violence narrative to try to get Irvin elected in the primary. Irvin lost. The gubernatorial nominee for governor is the even further right Darren Bailey, whose major benefactor is the largest Trump donor in the state, Richard Uihlein, who gave $28 million to a PAC and then another $13 million in a second installment. So more than $40 million to a PAC that has been sending literal fake newspapers with full 2-page spreads of mugshots of mostly Black and brown men that they say are going to be released into your community. They had this horrible fake ring camera footage showing a white woman walking down the street and gets grabbed by 3 Black men, and there's scream, which is just piercing and which is doctored. That part is fake. And then the last bucket of actors here is some of the court system actors and county boards and other folks who depend on money bail for to run their court systems. Cook County does that a lot less because of some reforms over the last 10 years, but many counties are running their county court systems on the backs of Black and brown women and people who are having to pay money bail. And so a bunch of those folks, whether it's the state's attorneys or the county clerks or other folks who are deathly afraid of raising property taxes and perfectly fine to run their court system on the backs of people who are presumed innocent.
Super helpful. I think that last point is particularly interesting because I know, we see these sort of boom and bust cycles of kind of mass mobilizations and then policy shifts and kind of new research in those areas, and then this backlash. And this, even though the setting is different, it's very similar, you know, that issue is very similar to Ferguson, right? Of where some of the information that came out of that mass mobilization, of that uprising for Black liberation, was also about how Ferguson as a city was running its municipal administration in part on the backs of fines and fees leveled against poor people of color. And I think that is a striking bit of information, particularly around bail, where we know that it's functionally then a temporary revenue stream, theoretically, right? Bail is returned to people upon the closure of their case. And so the fact that it's being run in that way, where it's different than a fine or a fee in that way, right? But still that there's such a concern about that disruption of the revenue stream, and also thinking about people's liberty being a revenue stream, right, is such a kind of grotesque manipulation of principles of the presumption of innocence, which is also at issue when we're talking about pretrial cases. So in terms of the campaign itself, you've talked about some of the tactics that they're using, this fake newspaper, but it seems like this in particular has gone viral in a way that maybe you all hadn't anticipated in your organizing model, which is very specific, it seems like, to our particular moment. So I'm wondering if you all can speak about that there's this kind of campaign effort, and it's happening in specific individual candidates' campaigns in this moment of the election, but also there's this more diffuse campaign of misinformation. How does that relate to the fact that it's an election year? And also how does that relate to why this has taken off in this way?
Well,
yeah, it definitely, the fact that it's an election year is pretty central to this. Especially, this isn't entirely a Republican versus Democrat issue. There is division within the Democratic Party in Illinois, and some opponents who are trying to water down the bill are like more conservative Democrats. But the Illinois Republican Party has gone so far right in the last few years that we have a situation where their positions on things like, taxing working people so they can give tax breaks to the rich and big corporations, opposing minimum wage increases, opposing abortion access, all this other stuff, that they are like desperate for kind of racist fear mongering as the central portion of their playbook, and so yeah, that's very much what they're doing, and then that has kind of created space for some more conservative Democrats who didn't love the Safety Act to start with to then kind of say, hey, maybe we need to like do some things to water this down, or to, in some cases, completely subvert the entire point of the legislation. But yeah, the fact that that these ads are out there, and in some cases going viral. I mean, like the newspapers and the Ring camera footage, those are like the obvious sources of kind of paid media that's driving this conversation. But a bunch of the social media stuff is also paid social media, and it's like a lot easier to have something really like that sounds dramatically ridiculous go viral on social media compared with the Pritzker campaigns like fact checking. And honestly, the Pritzker campaign, they have an interest in fact checking, but they don't have an interest in making this the central portion of they don't see their path to victory as necessarily like running through the Safety Act in a way that the Bailey campaign sees their path to victory running through the Safety Act. Because honestly, the Pritzker campaign's platform across the board is much more popular. So they're not trying to be a one issue show. So there's some like kind of an imbalance in the level of resources between when an election happens, there are hundreds of millions of dollars being spent on paid media in a way that is never true any other time in Illinois. And there's a real imbalance between just the amount of emphasis between the two sides in that paid media right now, in a way that is playing out, is having an impact on the public conversation in social media.
So let's talk about, we've talked about one side of this, but let's talk about the conversation aspect of it, like you just said. So in terms of the pushback and the legal and organizing responses, what strategies and tactics have you all used to promote and protect that policy shift? And kind of who's involved in the campaign? Sharone, maybe you can start us off.
Yeah, certainly, from the Cook County Public Defender's perspective, we have tried to correct the record in the media, right? We have tried to, and I think been relatively successful along with our coalition partners, to really get in touch with each and every piece of media, each and every journalist that we can, to really have them explore the lies that were being promoted both on social media, but also from, either elected officials and state attorneys or other folks, and it continues to this day where you see elected officials kind of say, oh, well, this is in the law. And then, we are out there playing defense and saying, well, first, this is not in the law. What is in the law is this. And this is the reason why we put this in the law, right? For example, there's been this story around electronic monitoring, and there's been this story around the law basically says that if a person's on electronic monitoring, very modestly it says, well, that person shouldn't starve to death, right? That person should have the ability to go to the grocery store, and that person should have the ability to go to the doctor's office a couple times, and do the things that they need to do to literally survive, that all humans do. And you will have elected officials, kind of really just not tell the truth about what that particular piece of the law says. So we've had to kind of do all of that fact checking. And I think, certainly, when somebody's spending millions and millions of dollars and there's this imbalance, as Will has explained, it's tough to have a loud megaphone. But I think we have been effective at kind of with legacy media and with our own social media, trying to tell the story about what's actually in the law first, but also why that existed and how that's impacted real people, right? Has been kind of our focus initially. Again, I'm operating the public defender's office along with a ton of other great people, and trying to, we're trying to do our best to represent folks in court. But there's also been an effort to just educate the public kind of on, at night, right? At least from the public defender's office, of just being in conversations like this and just talking to people kind of one by one about kind of what this law does. This law existed. This law was created really out of people power, right? Really out of organizing, right? And returning to that organizing kind of faith and getting people to really talk about why this law existed and kind of what dispelling the myths and the lies.
Yeah, and when Sharone says at night, I don't know when the man sleeps. He's been, the coalition has had, dozens of public information events with thousands of people. I feel like Sharone personally has talked to a significant number of those people. We've had folks knocking doors to talk about the Pretrial Fairness Act. So there's been a whole huge bucket of public education events, this bucket of media work to push back with the fact checking, but also letters to the editor, pitching stories, press conferences with faith leaders and elected officials. And then the third kind of bucket of this work has really been the electoral work, to make sure that that candidates and legislators know that when you do the right thing, you're not going to lose your seat because of it. That if you have the real conversations with voters about why why we needed to do this, and then what it's actually going to mean for people, that folks can get reelected, and some folks are, the example of Willie Horton has lived long and loomed large, but we also have the example of Anita Alvarez. So we're trying to show the elected officials that that not only is it good for people, good policy, good for a fair court system, it's also good politics. And then lastly, we've done a lot of just like straight up lobbying, talking to constituents, meeting with legislators, getting emails to legislators from people, whether it's on the doors or through email and social media, et cetera. We've been doing a lot of all of those different things to kind of push back on this misinformation and really get back to the kind of like Sharone said, the basic organizing that got us here in the first place. Like we didn't win this through mail. We won this through thousands of people in the streets. You know, from the first wave of Black Lives Matter protests in the wake of Ferguson to the 2020 uprising. Like there's no way we would have, like, this didn't just happen because of any individual moment. It really happened because of those moments kind of as bookends of a like years-long campaign that then also involved a lot of grassroots organizing, public education, lobbying, you know, electoral organizing, coalition building, with the people in the streets playing key roles at key moments.
Super helpful. So I think the next question I wanted to broach brings us back to what we put a pin in, that you know, the example of New Jersey and kind of what the evidence base shows about wholesale reforms to the pretrial system in states that have already done it, right? And so just to speak for a second about New Jersey, but then also to think about folding that into the kind of strategies and tactics you all just laid out. You know, when New Jersey moved to do bail reform, it opted to create, to adopt the Arnold Ventures public safety assessment risk assessment, right? And there was a important and dramatic decrease in pretrial detention in the state, and also no change to the overall racial disparities in pretrial detention in the years after that law was implemented. So I think one of the things I wanted to speak to about, and it's different in some ways than your campaign, which had really centered racial justice, like we talked about, right? And so the reforms that you all put forward maybe respond and hopefully anticipate trying to have a different story, be the story that's told when the Pretrial Fairness Act takes effect in January. I wondered if you could speak to that, and also kind of what elements of academic research are helpful to you in this moment of kind of putting forward a campaign that's rooted in truth, as well as kind of defending the misinformation, right? I think there are two different ways that one could approach this campaign, right? Which is just fact checking, as you're saying, each of these untruths, or going back to base building and thinking about what are the reasons that this is important in the first instance, kind of a priori. I wonder if you all could speak to that.
Yeah, I think there's some good points there. You know, certainly New Jersey is a state that essentially ended cash bond a few years back, and you know, we have used that, especially 2020 and 2021, as an example of this idea that the sky will not fall. And quite frankly, there would be significant benefits if you end cash bond. Now, there are little things, little details, if I got in the weeds about why New Jersey is different than Illinois, and you know, there are lessons that the Illinois statute has learned from New Jersey, improvements that we think that we've made. With that said, I mean, there's kind of a wealth of academic literature that supports our case. There are kind of so many different buckets. There is obviously the literature that we talked about before that talked about the harms of pretrial detention. You know, oftentimes, you know, when we are talking about public safety in the context of bail policy, you know, people couch public safety in the idea of, well, the only way to keep people safe, or the terms in which we talk about it, is like putting dangerous people in jail, right? And that is the way you keep us safe, because those people, if they were out, would continue to create murder and all the bad things, shootings and rapes, things of that nature. And I mean, you know, there is so much research that's been done in Cook County, because Cook County is engaged in a reduction of its jail population, to show that, you know, the bail reform before this has not, you know, been associated with any, you know, increase in criminal activity. That's, you know, stuff from Loyola University. There's stuff from Chicago Appleseed that talks about the small percentage of people who are on electronic monitoring who have been accused of a new offense. That was kind of another kind of a piece that was kind of out there that, an increased electronic monitoring increases crime. There's also stuff from, kind of faces that aren't necessarily seen as super reform minded. Organizations like the Crime Lab, that kind of looked at outcomes in Illinois and Cook County and found that the claims made around linking bail reform to an increase in violence is untrue. There's also kind of, we talked about before, the harm of pretrial incarceration itself, right? We know about the violence of pretrial incarceration in terms of when you put somebody in a box, you elevate their risk of being physically harmed or being sexually assaulted or suffering emotional harm. But we also know that short-term impact, right? When somebody's arrested for 72 hours or more, we know that they're significantly likely to lose their job. We know they're significantly likely to be rearrested in the next year. We know that their income levels can be reduced up to 40%. So there's kind of a wealth of information around why we do these things. With that said, I do think it's important to note that while we want to have an argument about data and we want to have an argument about studies, there is kind of an inherent immorality of the current system, despite the data. Like this idea that somebody should buy their way, buy their freedom is completely wrong. This idea that someone is innocent until proven guilty, but that innocence only attaches if they're wealthy is a baseline immoral. So I know I'm talking a lot, but
and I'd add one more onto that, Sharone, which is the thing that the law says, which is that pretrial detention is administrative and it's not punishment, right? That's legally in our law from 1987 from Salerno. So I think you're right to bring that up and to say there's this there are these deeper fundamental questions, and in some ways I asked about the research because I think the virality of this campaign seems to me like it's operating at the pitch of human emotion, right? It's playing on fear and it's playing on racism. And in some ways, the data and the research, which are the truth, also don't necessarily speak to that fear in the same way. So I think figuring out the mismatch of trying to tell the truth and debunk the lies and also meet people on the register of where the kind of opposition is shaping their conception feels important and really challenging.
Yeah, and it's really interesting because you have people who are in community. Harm in our city is very concentrated. For folks outside of Chicago, people talk about Chicago being a very violent place and Chicago being a very unsafe place. We can go back and forth about what is the tie between the reporting of harm and actual harm, but we do know that the harm is incredibly concentrated, right? So you have, concentrated areas of the city, right, that are suffering through this neglect and the harm that comes forth from this neglect. But it seems like those are the individuals, those are the people, first off, that continue to vote for progressive prosecutors because they understand that there's a dual crisis, right? They understand that there is a crisis of harm, but they also understand that there's a crisis of injustice. And quite frankly, those seem to be inextricably linked, right? That the harm that exists, right? The injustice that exists makes that harm continue, right? So when you're talking about a policy that pulls tens of millions of dollars out of communities every year, right? That has harm, that is violence, right? But that also creates the more traditional harm that we continue to kind of focus in on.
Absolutely. And I think bringing it back to connecting the disinvestment and the extraction of bail, right, of money bond is so important. And thinking about even when a person isn't detained by their bond, right, and it's not the problem of wealth-based detention, that bail gets paid by the family, that money was not supposed to go to that bail, right? That money was saved for food or for rent or for healthcare or for something else, right?
And we know that so much of that money doesn't come back, right? There's this idea, right, that you pay a bond and the person goes to their court date and they finish their case and that money's supposed to come back. We know from lots of studies, the study done by the Civic Federation that people should check out. I don't know if you link, that suggests, not suggested, but that details that so much of this money is removed permanently from communities, right? So, we were having an event that Will's group was sponsoring at 26 in California just a couple of weeks ago, about a month ago, and and it was in front of the jail, right? And it was in front of the place where people have to pay that ransom. And we had a woman walk through, right? And she's having conversations with people, and she actually said, "I'm glad you all are here, right? Because I had to bond out my son. He was having a mental health crisis, right? And I had to pay my last couple $1,000s, right, to pay that bond." And she asked a really good question, like, first, if they were going to let him go, why did I need to pay, right, that money that I needed to keep my family together? And she talked about how she didn't have that money, right? That is violence, right? That is harm that we're doing, and oftentimes that isn't calculated in the kind of traditional evaluation of public safety, but as a real effect. And the people who are living in that dual crisis feel that and understand that, and they want improvement on both sides.
Absolutely. I think I found the right link, Sharone, for the report you mentioned for the Civic Federation, but hopefully we can collect resources after the fact. I should have said this up front, and we will make all those resources and links available on our page as well for this event when it's recorded. So one other piece before we move into kind of implementation and next steps and where you all are looking ahead, thinking about staving off the detractors, but also actually getting this law into effect. Before we do that, I just had one more question, which is about kind of regional differences. And you spoke to this a little bit early on, Sharone, about the way that there's this real asymmetric distribution across counties in Illinois, but that there are some maybe legitimate concerns, you tell me, of smaller counties about building out the infrastructure to be able to run, for example, a more robust pretrial services operation if that's required under the law. Like, are there, in the year, almost 2 years since this passed, do you all have a sense for whether there are people who are earnestly trying to think about setting it up and encountering pitfalls, or is that all just sort of swept in with the kind of misinformation campaigns?
The state of Illinois has invested actually quite a bit of money in pretrial services. They made the decision, because remember, this happened in 2021. It was signed, so they propped up in 2 years, which is like warp speed in government time, an entire agency that will support pretrial services in I think about 60 or so counties, right? So and there is a kind of a conversation about our pretrial services, like how many pretrial services do you need, right, to support this system, right? I think personally, I've seen how pretrial services can be tied more to punishment than they are into ensuring somebody returns to court. So there's a real conversation to be had there. But we do know that the state has spent a significant amount of money on pretrial services. They've given a significant amount of money to law enforcement, right, to enforce, to implement other parts of the Safety Act. One of the things that they haven't done, and one of the things that we're imploring them to do, is to invest in public defenders. Cook County is the largest county in the state. We are underfunded office, but we are probably better off than all the other offices in the state who will struggle with before the Safety Act, and will continue to struggle after the implementation of the Pretrial Fairness Act. So when we're talking about those resource questions, I would love for the state to think about how we can ensure that people have adequate access to counsel. And I think you guys might be talking about that soon.
That's exactly right. We are. Our next event on November 16th. Thanks for teeing that up. So just in our, our last kind of 5 minutes of the moderated conversation, and then we'll open up the floor for questions, but also people should feel free to start dropping questions in the chat at any time. What are your all plans for kind of continued defense and building public support for this, both before and after January 1? And if you want to tag in that, any other kind of lessons learned for other jurisdictions as you're doing that work?
Yeah, well, we're going to keep knocking doors through November 8th. We being the groups specifically that have electoral capacity. But the whole coalition is mobilizing people right now for Springfield lobby days for when the legislature goes into session for a couple of special sessions after the election. We're amping up our public education and constituent meetings. Have a breakfast with a group of pastors tomorrow morning. Actually, both Sharone and I together have a breakfast with a group of pastors tomorrow to talk more about this and just doing all the question and answer for all the people, so people who want to hear the real story get a chance to have that conversation. And we're doing like public actions on some of the bad actors. We had a bus take a group of people out to see a couple of different state attorneys that were just like rampant racist lies were coming out of their mouths. And so we had a group of people, including directly impacted people, faith leaders, other people who are concerned about this issue, to go protest these two offices of these state attorneys that are just not negotiating in good faith at all around this stuff. So we're gonna keep fighting. We're gonna fight hard, and we're gonna make sure that on January 1st there are people watching court, supporting the judges that are doing the right thing, pushing the folks that might be reluctant to follow the law, and making sure that the eye of the state is on this question of whether court systems are gonna do the right thing, are gonna follow the law, are gonna follow the movement and the Black Caucus in the legislature that played a key leadership role in this and actually try something new on January 1st. And then we know there's going to be a whole other round of pushback on this and defense that we're going to need to play, and offense we are also going to need to play as next year rolls on. Every summer, summer violence gets blamed on bail reform, even before the law went into effect, regardless of any facts or lack thereof. Police can figure out how to blame a violent act on bail reform, even if the person has no connection to the money bond system one way or the other. The facts are not relevant to that. So we need to be, and we're planning on having folks ready for rapid response to push back on the overt lies, and also rapid response to be ready for those moments when someone is released under this new system and is rearrested for a dramatically bad offense. So there's a lot. We have our work cut out for us, and not just through January 1st.
Anything else to add, Sharone, in terms of lessons for other jurisdictions, or what you all are doing at the defender's office to get public defenders trained up to be able to interact with the law, or anything like that?
Yeah, the public defender's office certainly has had to. We're in negotiations right now with our union to create a new division that will allow for us to be better prepared to take on these new bail hearings. Let me jump into the weeds really quickly, right? What the new law does, it essentially says that we have two decisions: either you're in or you're out. The law is set up to ensure that there are a segment of cases that just won't be a part of that detention decision, right? These low-level cases. So now we have a subsection of more, kind of higher level cases, and it gives the system a better chance of really having a real serious discussion, right, about whether this person should be detained or not detained. And clearly, prosecutors and defense attorneys will disagree on a number of cases, but that is a very different model than the current system, in which bail hearings are first much quicker, and also we are over reliant on just kind of coming up with a number kind of out of thin air and letting that be the determining factor in whether somebody's in or out. So we are trying to kind of reorient our structure, creating a new division that would allow for us to have specialists in the new law that will kind of conduct these hearings, and there are also some other internal benefits, with that change. And then also we're just trying to be a partner with the coalition, supporting this work. And I think finally, just being involved in whatever conversations there are around cleanup of the bill. We do know that the General Assembly is looking at cleanup, and that was always going to happen, right? This bill had that long date to give us an opportunity to kind of see what was going on. So we've been trying to be impactful in those talks and ensure that we're talking about cleanup and cleanup alone, and not just kind of wholesale changes to the bill that would defeat its purpose because we've kind of, bought into the misinformation and lies. So, yeah.
Great. We've got our first audience question, and we do like to let people ask their own questions. So, Mike, if you are interested, you're welcome to unmute and we'll spotlight you and you can ask the questions you put in the chat.
Sure. Thank you. And thank you for this. It's very informative. I serve on a task force in Durham, North Carolina that's working on reform of the criminal legal system at the local level. And, one of them we're pushing and getting some good support for the idea of ending cash bail, but also to expand post-arrest diversion and pretrial services and pretrial supervision. So my first question was hoping you guys could elaborate on how the need for expanded post-arrest diversion into either specialty courts or other accountability programs and pretrial supervision as a complement to ending cash bail. And then if, time permitting, what about the effect of ending cash bail and preventing more wealthy people who've committed serious crimes from being able to avoid accountability? I mean, it seems to me that's, more likely to happen that people who really have committed serious harm to the public and shouldn't be out just because they can afford it. That's as more likely to happen as a good effect of ending cash bail as supposedly letting loose the mythical, violent, dangerous criminals onto the streets, which, as you say, shows there's just not, evidence to support that happening. But what about the other end of the spectrum?
Thanks, Mike. Sharone or Will, does one of you want to start?
Will, how would you want me to?
Go for it.
Okay, so let's talk about the second part first. Certainly, the supporters of ending money bond and reforming the system is a big tent, and certainly there have been arguments around this idea that wealthy people are able to bond their way out, and that is certainly something that folks find attractive. There are folks that find that attractive, and certainly that is a real argument. I may push back on a little bit of the idea about accountability. I think accountability happens when we make a decision about innocence or guilt, and bail. The bail decision is really only there to ensure whether somebody is to come back to court. But with that said, that is certainly
sorry, I should have that when I said accountability, I mainly meant to ensure people are able to go to court and have their case tried. That's what I meant by accountability. Thank you.
Yep. So certainly that has been an attractive argument, especially for a lot of mainstream Democrats. Certainly the prosecutorial community, the two big prosecutors in our state, have kind of pointed to that argument, as something that the community members certainly see that inequity, and so I do think that is something that people have leaned upon. I think to the first question, I think we have always been supportive of alternatives to incarceration, and our fight really has been around. And this may be just me. There might be others that have different opinions. We have one of our supervisors on the call right now, Michael Herzog, who's kind of on the ground. He may have different thoughts about this, but from my 50,000-foot ivory tower perspective, I really think that there are a lot of programs, but thinking about who is eligible for those programs, I think, is a really important deal. And oftentimes, what we see is kind of creaming of the top, right? The folks that are eligible for these programs are typically these mythical first-time, offender, first-time person who's never been arrested before, and they made one mistake. And we reserve these programs that I think give people what they need to survive. We give that to one person. With that said, I don't think we should be looking at the criminal legal system as a place where people should be getting the things that they need. In terms of pretrial supervision, certainly that's something that people have argued for. Again, I would say that we should be careful about over surveillance, and we should be careful about over conditioning people but certainly giving people the things they need to return to court, whether it's talking about transportation assistance or whether we're talking about court reminders, I think are always a benefit. I know Michael's not on the panel, but Michael, I would love for you to jump in if you have some thoughts about this question as well, because you're practicing and you probably see a lot more than me.
I know Michael's here because he helped provide one of the resources in the chat, or at least was here. But
and I did not tell Michael to jump in. I did not give any warning. I just popped up.
No pressure, Michael.
Bro,
But you're welcome to the panel.
I'm just gonna gas you up because you do nothing but encourage and empower your line attorneys as well as other managers. I appreciate the perspective that you bring, and I'm excited to be the background providing a link. So no, thank you, boss.
One other thing that question inspired before we move on to the next question in the chat is that there is a provision that's a little more upstream in this bill, if I recall, and tell me if I'm getting it wrong, that encourages, citation in lieu of arrest, right? So that there is kind of a intellectual consistency throughout the bill of saying, what if we did something less punitive in the pretrial space? What if we really protected the presumption of innocence? And so instead of post-arrest diversion, there's let's not even arrest people if it's a really minor offense, right? And I think actually implementing that through a culture shift in law enforcement is going to take a ton of work, but just having the seed of the possibility of that written into the law feels potentially groundbreaking. And maybe that's another way to think about Mike's question about other kinds of pretrial systems.
Yeah, well, I want to lift up the work of the policy team here in the coalition, of which I'm not a member, but a very appreciative supporter. But Sharone and the other folks who drafted and lobbied and advocated for this bill and discussed all the provisions that were going to be put into it did a really good job, I think, of looking for every possible opportunity to contract the the role of incarceration in the criminal legal system. And so the end of money bail and the significant reduction in pretrial incarceration is going to come out of that is, as you point out, kind of just one piece of this that also includes some of the and increased movement for people on electronic house arrest, and I think it points to the real care that this team of folks put into thinking through a sort of a whole new pretrial regime that is much more oriented towards keeping people out of the system in as many different ways as possible.
Great. Andy, you've got the next question in the queue. Would you like to unmute and ask that question?
Sure, thank you. So I would love to see Wisconsin make changes to our pretrial supervision similar to what Illinois has done, but the prospects for that happening are almost nil because we have a permanently Republican legislature that the Supreme Court has said is just fine to stay that way. That doesn't infringe on anybody's constitutional rights. So I'm wondering if you have any tips or advice for putting pressure on elected officials that really only have to answer to a primary challenger rather than a general election.
Yeah, this is definitely a Will question.
Yeah, I really honestly feel for you all, and I don't have any really good answers. I will say this is, we talked a lot in this session about lobbying and electoral politics and all that other stuff, and I think that one of the moments where we had to deal with judges who were acting just completely unaccountably. We had groups of people go and commit acts of civil disobedience, shutting down streets, shutting down courthouses. I think that when there's not actual democracy, I mean, I'm a fan of direct action, whether or not there is some reasonable amount of democracy, but I think it increases in importance when there isn't that. but I'm not going to pretend that there's a real answer here.
I'm gonna be a Pollyanna maybe, but tease out a couple of other things that I heard you say over the course of this event, Will, and see if that might be helpful food for thought, Andy, which is, this was the result of a 6-year campaign that started in a bunch of other forums, right? They started with first a localized campaign in Cook County, right, with the I-bond reform and doing monitoring of that and court watching and trying to bring it to the state Supreme Court and so I think one lesson, it seems to me, in this, where it ended up in the legislature, but that wasn't foretold that was going to be the effort from this bigger campaign that materialized in actually resulting in codified policy change. So I just wanted to name that as, have diverse strategies and tactics. And the other thing that's consistent across the story of this policy, it seems to me, is that it was base building, right? That this came from the groundswell of people who are directly impacted by the harms of this policy, telling their stories publicly and organizing among themselves. And so that, I think, is also a lesson that if you can, harness the power of the people in the work that Will does, but also then have, support from the legal infrastructure, right? That's the lesson of this coalition too.
Thanks for being more articulate about that than I was. You're completely right about that. And we often didn't know actually what the strategy was that was going to work. Like when we first started this, I really thought state legislation was the only thing that could work. And then we were doing actions around the chief judge that were as much to create publicity as to actually move him to act. And then he did actually act and made a transformative change that really impacted a lot more people than we thought was possible in the absence of state legislation. And then our next theory was that the Illinois Supreme Court was going to be the key actor. And we built the Illinois Network for Pretrial Justice because the Illinois Supreme Court was engaging in a process to try to consider enacting a statewide rule similar to the Cook County Affordable Bail Order. And then they punted to the legislature, and we had this kind of back burner legislation that then turned into the front burner and turned into the actual way that it worked out. But so it's not that we weren't doing like power analysis and trying to be intentional about what we thought was the right strategy, but we were on a good day appropriately humble about what we actually knew could work, and trying different things with that kind of like overall orientation towards people power.
Thanks for that. Thanks, Andy. Next up in the queue, we've got Joan with a question. Joan, do you want to go ahead and ask?
Sure. Hi, Katie. So my name's Joan. I am a new lawyer and I grew up in the Chicago suburbs. So always thinking about groups outside of Cook County. I'm wondering, what work are you all doing, or other folks, to help support public defenders in particular out in those other counties who are going to have these more intensive evidentiary pretrial hearings, maybe facing prosecutors who are upcharging to have more detainable offenses. What's being done to support implementation in those other areas, since it seems like Cook County is super on top of it?
Well, I would not say Cook County is super on top of it. I don't know if Sharone is still here. It is still a work in progress. There has been a lot of work though. We've been working on it for quite some time. I think the answer to that question is that we've been engaging with both the county implementation kind of system, but also the statewide implementation system. So we have been in meetings with the state Supreme Court and statewide actors that the state has brought together to work on these issues. We've been in partnership with both individual kind of counties, but also kind of a broader group of, we've been part of a broader conversation. With that said, I think our advocacy has always been that public defenders will need more support. They need more support now, and they will need more support. And we have been exploring ways that we can encourage the legislator to provide more support. We have really engaged with the statewide public defender network as well. We've put on trainings. We've tried to be a resource. We've kind of been there at both in-person events, but also kind of remote events. And we've really tried to focus in on helping to educate our own staff. And we have a long way to go there, even though we only have a month or so to go. But we've also tried to do that same thing with statewide public defenders, sharing resources is another big deal, right? All the work that we're trying to do, we're trying to make sure that we provide that for statewide defenders.
Awesome,
for
thank
that.
you.
So then we've got a question from Mike Liverwright. Mike, do you want to unmute and ask your question?
Is that me again, or is it a different mic?
Different Mike.
Yeah, all right, okay.
First. I'm not sure if Mike is still here, so I will ask the question, which is a pretty straightforward legal question. Is bail legally based on risk of criminal behavior while being out? Or what is the purpose of bail under the new Pretrial Fairness Act?
Yeah, well, obviously the traditional purpose of bail is to ensure somebody comes back to court. But the current law, or the law that will be in effect in January of 2023, allows for prosecutors to move for detention in kind of two different buckets, or really three different buckets, right? They can move for detention when they believe that a person is risk of willful flight from prosecution. They can move for detention when someone they would argue is a kind of a risk to public safety, a real specific and present threat to any person or persons. Now, again, there are limitations. There are hurdles that they need to meet, because the goal is to ensure that if somebody is to be detained, that it is kind of this, what you talked about Salerno, right? It's supposed to be the exception to the rule, right? So there are limited circumstances. I shouldn't say limited circumstances. There are standards that need to be met when it comes to detention, but certainly public safety or public safety type exception, or public safety reasoning is one of the couple of reasons you can move for detention.
Very helpful. And then Mike Systrom, you're back in the chat, I see, and I know asking about the question of kind of first appearance and whether somebody really has the right to counsel or not, which is something, I mean, you've perfectly teed up that we're going to be talking about in a few weeks here.
I thought that was the next week, so you could hold that for, I couldn't
No, I
remember.
mean, it's okay though. I think Illinois might have some interesting perspective on this to share, because I understand there's a statutory right to counsel at initial appearance there that passed also within the last 5 years. I don't know, Sharone, if you want to just spend our last minute on that briefly.
Yeah, that was something that passed in 2017. If Sharone's on the call, she could probably remind me. We work to get somebody a right to counsel. The reality of the situation, though, is that you can pass a law, and those are cool words on the paper, but that doesn't mean that that's actually going to happen. And I think what we've seen is that while folks have that right, they just haven't had the person power has not been there. So again, we have really thought deeply about how can we use our bully pulpit to ensure that there is adequate levels of representation at first appearance. But that's an open question. That's something that we haven't solved. Charlene, you can jump in if you like, but I think it's something that we're fighting. Charlene, threw in the chat. She's on the train. Sorry, Char. I'm trying to get all the public defenders just out here talking. Like, I'm such an asshole. I'm sorry. But
no, that's excellent. You're bringing your people along.
Yeah, but there was a great report written by the Sixth Amendment Center from folks that you're going to hear from in the next couple of weeks that looked at Illinois and saw that, hey, there's a real problem here. There's a real issue here. So we've been fighting to get people the access to counsel that they need.
We've got one last question. I know we're at time, but if you all will indulge, Lloyd McDonald's question. Lloyd, do you want to unmute and ask your question?
Sure. I'm just curious as to what the funding sources were behind the Fairness Acts being established and behind the organizations that are currently promoting its implementation without significant amendment.
Yeah, it's a kind of a variety of funders. Our donor bases includes individual members of our organization, and there's a set of like Chicago funders of community organizing and progressive policy. And over the last couple of years, as folks looked at Illinois to see that this is one of the places that pretrial reform is going particularly far, some more national funders have jumped in as well to support this work.
Thank you.
Great. Well, and with that, I think we're at the time mark, but I want to thank you both so much for being here. Such an informative conversation. And also, if there are ways that people can get involved in the work of this campaign, if they're local or not, I hope you'll share them with us so that we can push them out to the list when we advertise the recording of this event.
Thank you all for having this conversation. Excited to be part of it.
Thank you so
both.
much for having me. And thank you so much to all of our defenders out there that are fighting so hard every day in courtrooms. And thank you so much to our advocates that have fought so hard to make these changes possible.
Absolutely. Hopefully we'll have you all back and you'll really come to Harvard at some point, Sharone, I'm sure.
Only way I'll get there.
Take care, everyone. Thanks, everyone.
Bye.